SJC-13634 in the matter of an impounded case.
Attorney Warren, take your time.
Thank you, Your Honor. Good morning, Chief Justice, and may it please the Court. John Warren on behalf of the juvenile. We request reversal in this case. When this juvenile's mother was concerned for her 17-year-old son, she did the right thing. She intervened and she called the police. In return, she was forced to take the stand, and when she refused, she was handcuffed and brought to the bottom of the courthouse in the holding cell. That night, while her other children were in her Lawrence apartment, she was put on a police van and taken to jail in Boston. The next morning, she was brought back to the courthouse. And when she, facing the prospect of continued incarceration, this mother who had never been to jail relented and, sitting in front of her son, offered material testimony that led to his conviction. This cannot be what the legislature intended when it amended the parent-child disqualification in 2018.
Well, maybe not the backstory. We're talking about the legal issue of whether or not, when it actuates and whether or not it extends after turning majority. Now, we've said before, and if you look back at the case law from back when the 3 juveniles through the impounded case, when Section 20 was first promulgated, all of those cases deal with teenagers, right? The 3 juveniles case, the case that Justice Ireland talked about, how Section 20 was then enacted after the 3 juveniles case. And the original version of Section 20 talked about unemancipated minors. So when you look at this rule of disqualification, which we said it was, the rationale is the preservation of the parent-child relationship, and understanding that, and you certainly cited this in your brief, that we don't kick our children out after age 18. There is the rationale for, we're only going to protect that part up to 18 when folks are in the house, you're not an adult, you're not emancipated, and so that it would make sense that this rule of disqualification would only actuate when the child was under 18 and a minor, which is what the statute says, minor.
So I think Your Honor is right to bring up that the core intent of the statute is safeguarding the relationship between a parent and the minor child. And our reading of the statute does that because it affects how a parent relates to the minor child and interacts and communicates.
Your interpretation eliminates the word minor.
I disagree, Your Honor. I would suggest at the time a 16-year-old or 17-year-old is encountering problems, my reading, our reading, affects how a parent can communicate with that child and intervene. It affects how they can listen to their child and, if they need to, call the school, call a counselor, call the police, without fear that, hey, I can't learn too much because, for all I know, a trial's going to happen when the kid's 18, and then I'm going to be a witness in the case. So what it does is it protects that relationship between the parent and the minor child at the time that this stuff is going on.
But that's not consistent with the text of the statute, right? Because the statute talks about testifying, right? So it doesn't talk about when the case starts. It doesn't talk about that progression. It talks about the act of testifying.
I would suggest first, Your Honor, that the statute is ambiguous because although it does talk about testifying, it doesn't say when to assess minor child status, and it doesn't define minor child. And I'll give the court two examples, one of which is the spousal disqualification, which also, like the statute, bars testimony, but it doesn't depend on the marital status at the time of the testimony. It depends on the status at the time of the communication. And I think this court can see the legislature was concerned about communications between children and their parents because it's right there in the text of the statute. It's an exception to an exception in the rule that certain communications are to be protected. So we know that the legislature was looking back.
The statute doesn't talk about confidential communications. It talks about the act of testifying.
I would point Your Honor to the last section in paragraph 4. There's an exception to an exception that talks specifically about communications. I would suggest that evidences the legislature's intent to
Isn't it, though,
concerned about communications.
I do wonder if that exception to the exception, as you call it, shows that when the legislature chose to protect the communication between a parent and a child, when the child is a minor, they knew how to do it. Whereas that first sentence that you're relying on is about the moment of testifying. It
So
doesn't
I think
say, it doesn't say the parent shall not testify as to communications between the parent and the minor child. That would be a stronger case for you.
I think the legislature could have been more clear in either direction, and I suggest it's ambiguous. And I suggest,
Yeah, but one of the tools we use to resolve, actually before we say something is ambiguous, is to look at the statute as a whole. And here, as I was saying, it looks like the statute knew how to protect communications between a parent and a child. And it didn't use that same language in the first part that you're relying on.
So I think because it's assumed that it was going to protect communications. And so like the spousal disqualification, that also bars testimony, but it doesn't relate to the relationship at the time of testimony.
May I ask you I'm sorry. May I ask you a question? Do you have the statutory language right in front of you?
Yes.
Okay. So what I'm puzzled about is the end of the clause that you're relying on. So we're talking here about a youthful offender charge, correct?
Correct.
Do you see the language that says youthful offender proceeding in which the victim in the proceeding is not a family member and does not reside in the family household? I have two questions for you about that language. The first is, does it attach solely to youthful offender proceedings?
That's not how I read it.
You think that that clause attaches to everything that precedes it, despite the fact that there are commas separating it?
Reading it now, thinking about it now, I would say yes.
Okay. And then here, though, if that's the case, here, though, this case doesn't fall into that category because it's not a case about a situation where the victim in the proceeding is not a family member and does not reside in the household. So
Correct.
How does that help you?
It helps because it shows the broad intent of the legislature to be concerned not just about the time of the testimony, but about communications.
But no, because what you just did was narrow the scope of the protection, if I understood your answer correctly. You just narrowed the scope of this testimonial restriction to proceedings in which the victim in the proceeding is not a family member and does not reside in the family household.
That's not what I'm intending to do, Your
Okay,
Honor.
so does that language only attach to youthful offender proceedings?
No, Your Honor. But what I'm saying is,
All right, can we at least agree that this is not a case where I don't even know if there is a victim, but can we at least agree?
Not one of those cases, Your
It's
Honor.
not one of those cases. So how do you even fall within the statute?
I'm not saying that we fall within it. What I'm saying is the fact that the legislature is focused on communications gives insight to the fact they're not just thinking about this at the time of the testimony. And so
I tend to find if we adopt the other side's interpretation, aren't we just gutting this privilege? I mean, and allowing the Commonwealth to, you've got a 17-year-old, wait a little while, something that can happen when the person's 17. If we wait 2 days later to try the case, now all of this it just seems like it's going to defeat the entire purpose.
Exactly, Your Honor, because
And
parents
can I-
aren't going to
can I-
relate to
Can I
their...
lay on one more for you? Just
Yes,
then you
Your
can-
Honor.
I also don't understand how we're gonna, if the mother can't help the child when the child's in trouble, I just don't, then the parent-child relationship is gonna be severely damaged. I don't understand how this is gonna work for the legislature to limit it in the narrow way of testifying. So I know that's your argument.
That's
but-
exactly right, Your Honor. It's going to affect how parents are going to communicate with their children. It's going to affect how parents are going to walk their child through the criminal justice system,
Well,
which
Counsel,
we know that they're
I
required
have
to do.
to stop you there because you keep making this a confidential communication case, and it's not. It's just not. The mother calls the police because she sees a gun. This is not the question of what she said to her minor child. She saw a gun in the household, and she let a local detective know that I've seen this gun in the house. So this isn't a question of protecting confidential communications.
And parents aren't going to do that, Your Honor, if it's read the Commonwealth's way, and this mother likely wouldn't do it again, right? Because they under the Commonwealth's reading, they might be a witness in a trial, and so it protects the bond at the time that bond is needed.
Could I just pivot you to one thing, because I don't want to necessarily miss this, because I'm really interested in the issue of prejudice. Because let's just say that we agree with your interpretation of it, and I know you characterize this in your brief, that her testimony was critical to the Commonwealth's case. I just would like to push back on that a little bit, because the government is going to stand up here and say they went and got a warrant. The trial judge said you can testify as to why it is you were there, and Detective Ovalis, I believe, testified that he was the target. He testifies to going into the bedroom, seeing him laying on a bed with his head on a pillow, which is exactly where they found, and understanding that the defense said other people were there and there were all these other reasons why you couldn't really say he was the possessor of it. That was the testimony. So even with mom's testimony, even if we say mom shouldn't have been forced to testify, you still had Detective Ovalis's testimony where the jury could have come back with the guilty. So where's the prejudice?
Your Honor, first of all, what I would say is the Commonwealth doesn't argue that there wasn't prejudice in that.
Whether they argue it or not is beside the point.
And I would suggest there's good reason they don't argue when you look to, as Your Honor mentioned in an argument last month, look at how the case was tried, and you turn to the Commonwealth's closing argument, and you see that they're harping on the mother's testimony. In fact, they go so far as to say that the defense arguments, quote, may have made sense to the jury without the mother's testimony. The mother gives the Commonwealth 4 things in this case. The mother identifies her son, from the photograph. She says that she called the police about this juvenile and it involved a gun. She testified that she told the detective where he could find the gun in the home, and she testified that when asked if she'd ever seen the juvenile with the gun, she said it was always in the room. And you'll see in the Commonwealth's closing argument, they harp on all these points continuously and very strongly.
Those were all things that Detective Ovalis testified to.
Detective Ovalis did not specifically identify this juvenile from the photograph.
No, but he identified that juvenile as being the person on the bed
Right.
when they served the warrant with his head on the pillow under which they found this gun.
That's all true, Your Honor, and this is a case, certainly he was very close to that gun, in close proximity, but that's not enough, Your Honor, and there was no DNA or fingerprint evidence. As Your Honor mentioned, there were 6 people living in the house. One of them was the juvenile's brother, who was in that very room on another bed. They searched the entire...
How old is the other child?
I don't believe that's in the record, Your Honor. They searched the house, and there was nothing belonging to the juvenile in this particular room, and there are no incriminating statements made by the juvenile. So, Your Honor, I believe there is clear prejudice, particularly when you look at how the case was tried. And if I may, turning back, I did just want to highlight 2 other places you can turn to in the plain terms of the statute. Because I talked about that communications. A second one would be that this is not just a trial right, it concerns any proceeding. And I think you can look at that and say, all right, the legislature is thinking about this as applying throughout the pendency of the case. And another plain term you can look at is, although this isn't a juvenile-specific statute, the statute references specifically delinquency and youthful offender proceedings. And presumptively, this is going to be a statute that arises in the juvenile court. And because they're talking about juvenile court, what I would suggest is it should align with juvenile courts, how juvenile court proceeds, which is that there's continuing jurisdiction over pending cases, even though the child has turned 18. And this should align with the juvenile court. That's the only way that this statute makes sense. And frankly, it doesn't make sense to be determined on an arbitrary date, which is the date of the trial. That doesn't give certainty to inform how parents are to relate to their minor children and to help them through the court system. And finally, Your Honors, if I would ask you to consider the rule of lenity, and especially for juveniles, and point the court to the Hanson H case, which is a case where this court took a non-juvenile statute, but still considered Section 53 and interpreting the statute in the light most favorable to the juvenile. If there are no other questions, I rest on my brief for this and the other errors, all of which I would suggest were prejudicial in this case.
Thank you.
Thank you, Your Honors.
Okay, Attorney Cohen.
May it please the court, Jennifer Cohen for the Commonwealth. As to the parent-child disqualification, the Commonwealth's argument is purely one of statutory interpretation. The Commonwealth acknowledges that this would have been a very difficult situation for the mother, and those words are perhaps inadequate to describe the situation in which she was put. And the
She ends
Commonwealth
up jailed, right? I mean,
Correct,
just,
Your Honor.
is this really what the legislature intended? I mean, I understand they used the word testifying.
Yes.
That seems to, but, so the child, 2 days, you wait a week. Suddenly, the mother has to testify, but if the child's 17 years and 354 days old, the mother can't testify. We see just how damaging this is to the parent-child relationship here. You can't imagine the mother's put in a worse situation. The child's mother is the primary testimony against him. And the mother has done the right thing right from the beginning. She wants this gun off the street. She wants her child. But then she becomes the sword that, is used against him. Is this really what the legislature wanted here? I have trouble with that.
Well, Your Honor, I would say that in Vigiani, there's a footnote that points to concerns about pitting family members against each other. And I think that regardless of, disregarding this situation.
But we can't, because this is exactly the situation.
So I would say that the parent-child relationship is affected regardless of whether the court takes my interpretation or my brother's interpretation, because the legislature chose to include the word minor. As my brother and the amicus briefs have raised, the parent-child relationship is different from the marriage relationship in that it's continuing throughout your life, regardless. It starts when it starts.
Hopefully the marriage relationship is continuing.
Hopefully.
Too. Right.
But that relationship can be affected by a lack of disqualification, regardless of whether this is in the juvenile court or not, because that word minor is there. I get
it when we're dealing with children who are in their 20s or 19 or whatever, but when this happens, this child is a minor. Isn't their interpretation more logical that we look at the transaction itself? Well, did this happen when this child was a minor? And is the mother going to be testifying against this child about what occurred when the child was under her direct supervision? It just seems sensible.
There are no doubt good policy reasons for a statute on the disqualification to be worded as my brother
But
suggests.
when we interpret language, remember that classic line that we always quote, we look at the text and then we look at the mischief or whatever it is that the legislature is designed to address. And here that is protecting the parent-child relationship in the context of the prosecution of the child. We don't want to make the mother again, I don't know how to describe it, basically the primary and determinative witness in the case against her own child.
So I do understand the court's point, but again, I think that the operative word here is minor, and that the court could have protected this relationship in perpetuity, but it didn't. It chose to include the word minor because it drew a line at a specific date. And I would say that this paragraph must be interpreted in line with the other paragraphs in the statute.
How does the mother do her job as a mother when the child is a child if she is then going to testify about what she did, the moment the child turns 18?
I understand that policy-wise, this is difficult, and I don't think that I have a very good answer for Your Honor.
Well, aren't all of these disqualifications and privileges things that we look to the legislature to balance between the preservation of the spousal relationship, the parent-child relationship, and the public's right to truth-telling? And so each one of these involves a balance. And so I guess I wonder if the Commonwealth's position is not sort of strict construction on the word minor, but really that the use of both testified and minor child indicates the legislature's line drawing in that way.
I would agree with Your Honor, and I think that testifying, time of testimony is the operative moment here, just as it is with the spousal privilege. I think, as Your Honor pointed out earlier, the legislature chose the words that it did, and I think the court must interpret those words in line with its interpretation of the other paragraphs within the statute.
So how do we avoid the gamesmanship that really seems to be the crux of here? Because as your opposing counsel has said, unlike the spousal privilege, which is just at the moment of trial, right? This one goes from inquest to grand jury to trial to indictment or complaints, other criminal delinquency, and youthful offender proceedings. So it seemed like the balance that the legislature was striking was broader, actually, than the spousal privilege. So what is your response? So the parent is not allowed to testify at the beginning, but then suddenly the child turns 18. Why would that make any sense?
Well, Your Honor, I would also, and this isn't an endorsement of delaying trial in any way, but what I would say is that mischief can be done upon the court in the context of the spousal privilege as well. And I would say that obviously we don't want.
But not in the same way. Are you talking about people getting married in order to avoid testifying?
Yes, Your Honor.
Yeah, but this is not something that you can just concoct.
No, and it is different.
So that
it is different.
It's totally different, yeah.
But I think that nonetheless, I suppose during the course of proceedings, someone could choose to marry where they perhaps could not
At all? Choose to have a child? Is that what you're saying?
No, that they could choose to use the privilege at trial where they weren't at an earlier proceeding. I think that I don't have a good answer for Your Honor about how that can be avoided and how it should be avoided. But again, I do think that where the statute.
Well, you could just say that it will be assessed at the moment of arraignment.
That's a possibility, Your Honor. I would say that's not in the statute, and again, I would say that
but neither does it say at trial, nor does it say at the time of communication, right? So you could avoid the problem of, aging past minorhood by picking it at an earlier date, like a date that's actually within the control of the Commonwealth.
But then I would say, Your Honor, would the spousal privilege be assessed at the time of arraignment? I think that's not something that has been read into the statute by the court, and I don't think the court could read Your Honor's suggestion into this paragraph either.
I actually have a different question for you, which is the same question I had for Attorney Warren, and that is the language that is at the end of the first clause. Do you read that as attaching to every part of the, all of the proceedings?
Yes.
You do, so it applies to everything. So then what does it mean? I mean, because what, do we have a victim in this case?
We do not have a victim.
Okay, so how are we supposed to interpret this?
I think the legislature was carving out the opportunity for testimony from a child or a parent in an instance where there's domestic abuse or like inter-family violence of some sort.
So are you saying that this, I'll just call it privilege as a shorthand, but I don't think it's really a privilege, applies only in proceedings in which there is a victim in the proceeding is not a family member and does not reside in the household? Family household?
I read this to mean that a parent or child cannot be called to testify in the circumstances listed unless the victim is someone that lives in the household or is a family member.
And then only can testify to anything that's not the communication about legal advice.
And I think that is indicative of the careful line drawing that was undertaken by the legislature.
Did you do any, sorry, are you done? Did you do any legislative history on this? Did you look, because this is a modified when in 2018, is that? When
Yes, Your Honor.
And was there anything useful that you discover on what they were intending to do and why they made this change?
I didn't find anything useful, Your Honor, and to be honest, the most that I found was in the footnote of the Vigiani case.
Well, they did a wholesale swap out of the this was the prior version of it.
It related just to the parent.
Yeah. But can you please, again, I know that Attorney Warren says that we should look to the closing argument, but I'm still stuck on the prejudice issue. A lot of what Mom testified seems cumulative of what Detective Ovalis testified to, and that there seemed to be plenty upon which a jury could return a conviction just based on what Detective Ovalis was properly allowed to testify to. I'm not even talking about the video. Can you talk to us about the prejudice analysis, even if we were to find or construe the statute the way Attorney Warren was talking about?
Sure, Your Honor. So I will be honest, the Commonwealth did not argue that there wouldn't be prejudice in this case. I think I understand what Your Honor is saying, that the testimony is essentially cumulative, but the Commonwealth has to acknowledge the fact that when someone's own parent testifies against them, that is extremely powerful. So I think it would be hard to argue that there wouldn't be prejudice in these circumstances.
That the detective served a warrant that he was the target of and found the gun underneath in the room that he found him on the bed?
So I think where you have a mother who's extremely emotional, clearly does not want to be saying what she's saying, I think in those circumstances, notwithstanding Detective Ovalis's proper testimony, the testimony of the mother would have been very damaging to the case if it was not properly admitted.
Mm-hmm.
Counsel, can I ask for a clarification about your brief? So there's a discussion about, sorry, can we switch to a different issue? This is about the lack of written findings on sentencing. So most of your argument on that is that the juvenile was not prejudiced because the judge made extensive oral findings. And then you give a CF citation to an appeals court decision saying that an oral recitation of reasons for revocation, when transcribed, satisfies the requirement of a written statement by the fact finder. You don't develop an argument that the statute requiring a written statement of reasons for a sentencing is satisfied by the fact that a judge's oral findings may be transcribed. Are you conceding that the statute was not followed here and only making a prejudice argument, or are you trying to argue that the holding of King, that case, applies here?
I am acknowledging that the proper procedure was not followed. There should have been written findings in this case. However, because of the judge's extensive oral findings, once they were transcribed, there's no prejudice to the juvenile.
Okay, thank you.
If there are no further questions, I'll rest on my brief.